This intense courtroom moment captures a dramatic clash between a judge and a highly uncooperative defendant who identifies as a sovereign citizen. Right from the beginning, the defendant disrupts the proceedings by refusing to acknowledge his legal identity and repeatedly challenging the court's authority and jurisdiction. His arguments, rooted in unconventional legal beliefs, quickly create tension and confusion inside the courtroom. As the situation escalates, the judge remains firm and focused, trying to maintain order while giving the defendant multiple chances to follow proper legal procedure. Despite constant interruptions and defiance, the judge makes it clear that the courtroom operates under established rules, and choosing to ignore them will only lead to serious consequences. The defendant, however, continues to resist, insisting on his own interpretation of the law. Throughout the hearing, the judge issues several warnings about contempt of court, emphasizing the importance of respect and discipline in legal proceedings. Instead of engaging in endless verbal arguments, the judge directs the defendant to submit his concerns through formal written motions, reinforcing the structured nature of the legal system. In the end, the court sets clear deadlines for motions, responses, and the upcoming trial, showing that even in the face of disruption, the legal process continues to move forward. This moment highlights the challenges judges face when dealing with difficult individuals, and it offers a revealing look at how the justice system balances patience, authority, and due process under pressure.
I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me, the caps. I'm not that caps. Are you operating in commerce? Are you operating in military? What capacity are you trying me in? It's not explaining nothing. I'm asking you to explain which jurisdiction are you heading?
Get your full name, Mr. Little.
Bernard.
Your full name?
Bernard. I'm not the corpse. I'm not the corpse. I'm not the fiction that they send me, the caps. I'm not that caps.
So who gave you the last name Little? Your mother?
The government did.
Your mother didn't give you that last name?
The government gave it to me.
She had to tell the government, didn't she?
The government. She was an agent of the state.
She was an agent of the state? All right. What are we going to do with these cases, Mr. Little or Mr. Bernard?
I would like to know which jurisdiction I'm being tried under so I can adequately defend myself, Your Honor.
Read the court rules. I'm not here to give you a law school instruction. Read the court rules.
What do you mean? As a matter of record, I would like it to be placed on a matter of record how I'm being, what venue you are using, Your Honor.
That's not my obligation, okay?
What do you mean it's not your obligation? It is your obligation. You took an oath to uphold. Excuse me.
Mr. Little.
Yes, sir.
Let's stop, all right?
What do you mean, stop?
Don't talk while I'm talking, first of all.
Yes. Yes, sir.
All right. Secondly, it is not my obligation to read you the court rules. You're here. If you don't want a lawyer that is...
I'm not asking you to read me the court.
I'm not finished talking. If you don't want a lawyer that's versed in the rules, then you are obligated to know the rules yourself, what kind of jurisdiction it is, and all of that stuff. I'm not here to teach you that. I'm here.
You're not here to teach me, but you're here to inform me what jurisdiction that you're operating in, so I could defend myself. I'm not asking you to teach me anything. You're not teaching me anything. You're notifying me of what jurisdiction that you're operating in. Are you operating in commerce? Are you operating in military? What capacity are you trying me in?
This is district court.
That's what I'm asking. That's what I'm demanding. I'm not asking you anything. I'm demanding you tell me what process are you charging me of? Or are you charging this fiction of? Are you trying to get the bonds? I'm trying to figure out what's going on. You haven't notified me in the capacity how to defend myself.
This is district court. These are criminal cases. Read the Michigan rules of court.
That's not explaining which venue you are attacking me with. That's not what court. The court is the court 36th district is not a venue. It's a place. It's an establishment.
It explains everything.
It's not explaining nothing. I'm asking you to explain which jurisdiction are you heading me in? That's a simple question. Why are you running from the question? That's the answer. What's the problem with you answering the question, Your Honor?
You're going to be the third person that I give 30 days for contempt of court to if you do not.
Why would you do that? Why would you do that, Your Honor?
Wait a minute. There's going to be some proper decorum in here, right? You're not going to sit here and you're not going to overtalk me. I've given you the answer to your question. If you don't like the answer, let me finish. If you don't like the answer that I'm giving you, then you file a motion on whatever you think jurisdiction is and wherever you think the case should be dismissed.
It's not about what.
Now you about to go there, all right? One more time, you interrupted me, and I said that gives you your opportunity to speak to the court through a motion. So whatever you say, whatever kind of path you want to take with these cases, I'm going to give you the opportunity to do that. But you have to put it in writing now, okay? So I can read it, the city can respond to it, and then I can make a ruling off of who I think is in accordance with the law. All right, Mr. Little?
You still, Your Honor, I'm trying to address this matter properly. Okay.
And I'm telling you how to address it properly.
But you still haven't told me what venue you addressing me in.
I just told you, you didn't like my answer. So with that being said, we're not going to go back over this again. You're going to either set the matter for a pretrial date. I'll give you an opportunity to write motions and you can put whatever you feel that the law is at the state of the law as you know it, or the state of the law as it is, or with the court rules and the statutory laws and everything. You can put that in there, and then I will let Ms. Snyder or somebody from the city law department respond, and then I will make a ruling on how I feel who's on the right side of the law or not. Okay?
Your Honor, am I on record?
You are on record.
I would like to make a matter of record that Your Honor hasn't answered my question properly. Okay. I'm not satisfied with Your Honor's answers to my questions. I also feel as though I've been threatened. I feel like I'm under duress right now or coercion. I like that to be a matter of record. And I'll let you do what you got to do, Your Honor.
Okay, so we have a jury trial date already set for 4 of the cases. We'll add these other cases to that jury trial date on May the 7th.
May the 7th?
And these motions, let's give you a motion date before May the 7th. Why don't you give me the motions by April the 26th, your motion will be due. So that's a time where you, that's April the 26th, 4/26/2024, motions due, and the response to those motions, if you write them, will be on Friday, May the 3rd. The city will respond if they choose to. Respond, and then we'll set a final pretrial date, on May the 6th. So your next court date will be a day before the jury trial date on May the 6th, and then I'll make a ruling on the motions on that day. I'll have read your motion. I'll if the city responds, I'll I'll read their response, and then I'll make a ruling on the motion, and we'll see if May 7th that we need that order that jury. All right. You have any further questions, sir? So you put whatever you need to put in that motion, however you feel the state of the law is. I would like to be able to read what you're talking about, because I don't really understand your position right now. All right.
We don't understand each other's position, Your Honor. That's what we're trying to come. That's what we're trying to come together with.
And that's why, that's the purpose of the motion. That's the purpose of putting all of that information you have in the motion, so I can read it and review it. I might not still understand it. We probably are not going to understand each other's position.
Oh, you will, Your Honor. You will, because it's your language. It's your language.
I'll read it. All right.
Yes, sir.
All right, and just moving forward, let's not argue about the situation. Let's have a conversation about the situation, so we can have a little bit better decorum next time. All right, Mr. Little?
It's never argument, Your Honor. It may be agreement. You know, because I'm passionate about it, because my life on the line.
Right.
Not only my life, my trust. So, you know, there's a lot going on that, you know, ones ain't aware of, that I'm aware of, as far as them bonds and things of that nature. So, you know, I'm fighting.
As the hearing wraps up, the tension in the courtroom may settle, but the impact of what just unfolded lingers. Despite repeated interruptions and challenges, the judge successfully maintains control, reinforcing that the legal system operates on structure, not personal interpretations. The defendant's refusal to cooperate only adds complexity to his situation, showing how disruptive behavior can work against one's own interests in court. Even in the face of chaos, the court stays focused on procedure, setting deadlines, outlining next steps, and ensuring the case continues to move forward. It's a clear reminder that the justice system is designed to function with or without cooperation, and those who choose to resist it often face stricter consequences. In the end, this moment highlights the balance between patience and authority inside a courtroom. It shows that while every individual has the right to be heard, those rights come with responsibilities. As the case moves toward trial, it leaves viewers with a powerful takeaway: understanding the law is crucial, because ignoring it doesn't stop the process, it only makes the outcome more difficult.